drive and fly if that's okay. Judges, this case matter rather comes out of a decision by the trial court to, in its interpretation, if you will, of a force majeure clause in a commercial lease. The background here is that my client, Drive and Fly Out LLC, was a tenant to the lease. They are an off-site parking facility that serves the persons coming and going from Southwest Florida International Airport. They were under this lease for some time. It was renewed in 2015. And then in 2020, as you know, the coronavirus pandemic began to make its appearance, at least in January of 2020. There were declarations and administrative matters that were taken up in March of 2020. I think it's undisputed below and here that the first time my client missed paying rent was in March of 2020. And
before you get into the details of your force majeure, let's talk a little bit about the administrative aspects of the case.
Yes, sir.
Could you describe for us why you think this was timely filed and that jurisdiction is appropriate?
Yes, Your Honor. And I expected that to be an issue. I have reviewed the cases that were cited by my learned colleague, Mr. Brockmeyer. The major distinction in those cases and what we have here is that in the agreed final order of possession, which is what they believe to be the final order or final judgment, there is no reference to the counterclaim that was brought. There was a counterclaim here brought for wrongful eviction, a declaratory action of the force majeure provision of the lease, and as well as malicious.
Mr. Morgan,
yes, Your Honor.
the order that we're looking at for the possession of the premises is an agreed order, and it recites that the complaint has been rendered moot, and your counterclaim is tied, it's essentially a compulsory counterclaim, to the claim for possession. So in the context of a moot complaint and agreed surrender of possession, what's left of the counterclaim and that would somehow keep this case alive beyond 30 days where we have an agreed final order of possession? It didn't have, the order of possession didn't have to recite magic words like go hence without day or something like that to be final as to the litigation between these parties. Help me out.
I don't disagree, Your Honor. It does not need that language. I think the distinction here, though, is that there's no finality to the declaratory action, the count for the declaratory action. I agree. The malicious prosecution, the wrongful eviction counts tend to be caught up in this order, although it only addresses in language, if you will, the complaint. The problem is we don't have a declaration as to the force majeure clause. And I think that's important because, quite frankly, it's why we are here. I will concede to the court that the second final order, the final order regarding fees, and I think it's referenced as a final judgment, also does not address the declaratory action part of the counterclaim. And I guess the argument could be made, it has not been made, that we still don't have a final order as to that issue. But I believe, to answer your question directly, the issue related to the declaratory action and the fact that there is no final resolution on the merits as to that declaration, meaning there's a declaration that the force majeure clause either applies or it doesn't apply, is not referenced in that agreed order, that first agreed order.
Okay, so let's back up. You're conceding that the malicious prosecution and other counterclaims besides the declaratory relief are off the table. And the only
I don't like the word conceding, but yes, Your Honor, I think that it can be at least inferred from that order that those issues were, one, compulsory, and two, are finalized, if you will, in that agreed order.
Okay, so with that, we have your argument confined to the declaratory relief claim. And my question to you about that is, when you agreed to entry of the final order of possession, did you not waive further proceedings on the declaratory relief claim? Because what's left?
Right. And Judge, the answer to that is no, I don't believe that we did. That it was handled by a prior counsel and my client, but I believe that the thought there, the intent was to hand over possession of the property so that there were no longer any need for evidentiary hearings as to the turnover of the possession of the property. And that's what that agreed order was intended to address. I will point out then and go back to my discussions regarding the force majeure clause. Our position is twofold there. Either the trial court erred in not interpreting the clause, giving it its plain and unambiguous meaning, or alternatively, if it's believed that the clause was ambiguous, that the trial court erred in not giving a more reasonable interpretation of the full context of that provision. We believe that the error is the same either way. When we look at the force majeure clause, it refers to events that hinder or delay performance under the contract, and those events include strikes, lockouts, labor troubles, riots, insurrection, war, or other reason of a similar nature. And our position is that's where the trial court erred. He discontinued reading past the terms similar nature, and he used similar nature to construct an interpretation that basically was that the force majeure clause only applied to man-made types of events. Our position is either that the force majeure provision is clear and unambiguous because it should be continued to be read past the term similar nature, because it goes on to say that is not the fault of the party delayed in its performance, which we believe further describes, if you will, the terms similar nature, meaning that the purpose of the force majeure clause is to forego the responsibilities of the delayed party, the performance by the delayed party in those events that are not caused by their own actions, not just man-made, but obviously issues like the pandemic, which led to various quarantine and travel restrictions, which of course would be important to an off-site parking facility at an international.
So, Mr. Morgan, just to, I'm sorry to cut you off, but here's the question that I have that sort of goes back to where we were. The complaint in this action only sought possession. There's not a count for damages. Your client agreed to surrender possession. I appreciate your arguments and am happy to engage in a textualist discussion of the meaning of the language in the force majeure clause, but I am a little stuck on jurisdiction. And the reason I'm asking about this is if the complaint had pled a cause of action for damages, and there was still or if you were in a separate, as the landlord could do, suit to recover damages for the breach of lease, I think this would all be highly relevant, or at least has the potential to be. But here, where the whole shooting match was possession, and the landlord either could have brought a claim for damages in this action or could do so separately, the force majeure clause would be relevant to an ongoing liability, but your client surrendered possession. So what would we do? Give an advisory opinion on what the force majeure clause means in this case?
Thank you, Your Honor. And that goes back to why we believe that the declaratory action is so important and should have had a final resolution on its merits. There is still the ability of the landlord in this case, I'm not saying whether they will or won't, but they have the opportunity to bring in an action for damages.
And when they do that, you can raise the force majeure clause as an affirmative defense and get your declaration or a counterclaim and get a declaration on that. But why would we issue a declaration in this case where all the relief that was at issue,
Judge,
or why would we require the trial judge to do that after the parties have stipulated that the entire claim as far as possession has been resolved?
Judge, I believe that the summary judgment order there were competing summary judgments, as I'm sure you're aware, would be the law of the case, if you will, in that action for damages. In other words, part of the reason why we've asked for a declaration is to have a clear declaration as to whether the force majeure clause applied or didn't apply, so that issue alone could be appealed. I'm afraid that if there is a case brought for damages, that the summary judgment order and the findings in that order would apply to that case. And so we would be left without remedy or the ability really to bring forth the affirmative defense of the force majeure clause at that point. And that's why we have said all along that the declaratory action needed to be finalized on its merits in a final judgment, which would then start the clock, if you will, for the 30 days. So this all ties together. Back to the force majeure clause, unless you have further questions on that issue. The same applies if the court decides that for some reason the force majeure clause is ambiguous. We still believe it has to be read in its full context and given a reasonable interpretation under the case law. And the only reasonable interpretation it requires, if you will, the trial court to read the full context of that provision. The last part of that provision being that these events are not the fault of the party delayed in its performance, which would include matters and issues beyond just those man-made events that are cited within the provision itself. And so
I'm sorry, Mr. Morgan. I know we can, obviously the jurisdictional issue is one that's important and that we have to be jealous of. My question, looking at the summary judgment order and taking into account your answer, and I understand your argument, I appreciate your direct responses, but the summary judgment order was entered almost a month before the final order on possession. And if we accept your theory of this being potentially law of the case, et cetera, what you just said, then the question is, contextually, when you have what's called a final order of possession in a case where the primary claim is possession of the property, and you've got your declaration in the summary judgment order, the trial judge didn't buy what you were selling, you don't like it, there's something to talk about. But what troubles me is that then when your final order of possession was entered on December 16th, that order was appealable and the summary judgment order had merged into it so that you could have had a merits review of that ruling on an appeal timely taken from the final order of possession. You didn't have to wait for the fee judgment.
Judge, I agree we did not have to wait for the fee judgment. I do believe we had to wait for a final resolution on the declaratory action. While we could have appealed the final order of possession, possession was not the issue. It was avoiding evidentiary hearings for the turnover of the property. That was the purpose of that order. It was not intended to be a final judgment in the case. As it turns out, obviously that's the argument from opposing counsel. Again, whether we want to call it law of the case or practically speaking that whatever opposing counsel might be on the other side of the damages case, certainly that summary judgment order is going to be used to defend, defend, if you will, our affirmative defenses, assuming we're able to set them forth. Either way, we were looking for a declaration that would say either, and likely in this case, it would have said that the force majeure clause did not preclude performance by my client, but we need that adjudication on the merits in order to appeal that specific issue. So I understand the argument that the fee order may not have necessarily been the order that addressed that issue as well, but it's the last thing that we have, quite frankly. And so we appealed based on the date of that final order. Again, the purpose of
I did not see in your briefing any argument directed to the fee award.
Correct. We have not, we're not appealing the fee award itself. That's true. We are appealing, and as I conceded before, I don't know that we have a final judgment on the declaratory aspect of the counterclaim, but we are appealing I guess, the summary judgment order in the best way that we can, utilizing the last final, it's referred to as a final judgment, that was filed regarding the fee issue. Go ahead. I'm sorry, Your Honor, go ahead.
I was acknowledging your response. Thank you.
Okay. Again, I believe that I'll just summarize by saying this in terms of the jurisdictional issue. I believe that we needed a final decision on the declaratory action aspect of the counterclaim, that we did not have that in the final order on December 16th, the purpose of which was to turn over possession without the necessity of evidentiary hearings. We have a final order from which we did appeal, and I believe the jurisdiction is conferred upon the court, at least based on the timeliness of that appeal from that final order. In terms of the force majeure clause, we believe that the judge should have reviewed it in its full context and either given in its plain meaning to include any event that was beyond the parties' abilities to prevent, or from a standpoint of whether it may be ambiguous, and to have given it a more reasonable interpretation in light of its full context. With that, I'll turn over the argument.
Thank you, counsel. Voila. You have just seen or almost seen my technological skills at progress. I've managed to clear the clock. Otherwise, Mr. Brockmeyer, you might have started with not as many minutes as you thought you were going to get. You might have said time really flew. We are ready, counsel.
Brevity, however, may have been welcomed.
Thank you. Very kind. We are ready for your presentation, counsel.
Thank you, Your Honor. And may it please the court, Alex Brockmeyer on behalf of Midway Promenade LLC. Mr. Morgan and I know each other very well, so if I slip up and call him by his first name, I do not mean to offend the court with any informality, nor him. That being said, I want to go to the court's questions, which focused on the jurisdictional issue first. And I think the court's right. There is no jurisdiction in this case because Dragonfly did not timely seek review of the agreed final order of possession that the trial court rendered on December 16, 2020. And like this court has noted already this morning, the final order of possession was an agreed final order. And Dragonfly agreed that everything in this case was moot and that Midway Promenade was the prevailing party in the action, and as the prevailing party was entitled to fees and costs. This entire lawsuit, as Judge LaBritte, you noted, was all about possession. That's all this case was. That's what the DEC action is about. That's what the wrongful eviction and malicious prosecution.
Well, your client makes a compelling point, or your opponent makes a compelling point about the fact that the final order doesn't mention the counterclaim. You all undoubtedly were aware that it was out there, and that he's now confronted with a potential law of the case problem on the basis of an agreed order that, from his perspective, contextually was designed to eliminate a discrete issue, possession in and of itself, and avoid evidentiary hearings on that. He cited some case law about counterclaims and things like that. Tell us why, and I'm not sure that the idea that the fee order, the final judgment on the fees, would necessarily be the last act here. My question is, should there have been a final judgment on the counterclaim, or should the final order have disposed of the counterclaim? Why isn't it still hanging out there?
It's not hanging out there, Your Honor, because of the fact that, one, I dispute Mr. Morgan's contention that this was only designed to get rid of an evidentiary hearing on entitlement to possession. This final order declared a prevailing party. And like this court in Hutchins noted, you do not declare a prevailing party until all the issues on the merits are resolved. That necessarily would include this declaratory action count in the counterclaim. If that were truly the case, then seemingly somewhere between December 16th, 2020 and July 7th, 2021, when Dragonfly then agrees to the final order or judgment on fees and costs, it would have said, Judge Gill, we don't have a final order here on all the issues such that you can declare a prevailing party. You can't put that into this order on possession. You can't enter a judgment against us on fees and costs. But yet Dragonfly agreed that there was a prevailing party. Dragonfly agreed to a judgment to be entered against us on a prevailing party theory. If all the issues were not resolved, Dragonfly does not agree there's a prevailing party in this case. That's because, and the reason Dragonfly agreed that Midway was the prevailing party in this action. And I think that's important because when we speak of an action, we speak of the action in its entirety. Dragonfly knew everything in this case on the merits was resolved. So when we look at this and we look at the order as a whole, and we know that everything in this case, whether in the complaint or the counterclaim, is about possession. And then we look at paragraphs 3 and 4 of that order that declares the prevailing party, makes the finding of entitlement to fees and costs. We know that the case on the merits is over. And if there's some reason that somehow this wasn't over on the merits, we have 7 months that elapsed. Seemingly, Dragonfly would have taken some action to prosecute that deck action count rather than simply agreeing to a final judgment on fees and costs on that prevailing party theory. It did none of that. All of its conduct is completely consistent with what we are arguing here on appeal, which is that this case was final on the merits on December 16, 2020, which then takes us to the cases that we cite, Ginelli, Grassland, and Hutchins. And as my opponent conceded, Dragonfly is not arguing anything related to the actual fee judgment that it filed a notice of appeal
Which
on.
would be hard since it was agreed, right?
Exactly, Your Honor. So then that puts us then in the context of, well, Ginelli and Grassland provide this court with one avenue of resolving this case, and Hutchins provides an alternative one. Ginelli and Grassland just dismiss the appeal. I think this court has the precedent right there to do just that, which is what we've requested. Alternatively, what Hutchins did, it just struck the appellant's briefing on everything that was untimely appealed. If the court's inclined to do that here, then I would submit that the only other result could then be to have this court affirm, because it isn't, as Your Honor noted, seeking review of anything, nor frankly, I think could it, given that it agreed to the final judgment. Either option is agreeable to us. I think this court has precedent on both types of relief or resolution that we're asking it to do. And so that's how we submit this case should really just be resolved in the first instance. The review was not timely sought, and Ginelli, Grassland, and Hutchins all hold you cannot use a final judgment on fees to revive your review of a final order on the merits that you did not initially seek timely review of. Turning then to the merits.
Counsel, before you segue to your next point, I was hoping you might help me out on paragraph 2 of the agreed final order of possession. In part, that sentence, paragraph 2 reads, renders the further pursuit of the complaint moot at this time. Normally, before the comma, renders moot would suggest that everything has come to an end, but the next language following the comma suggests at this time. That's my concern, whether it meant to bring it together and resolve it all at once, or if this action is moot, wouldn't normally the trial court enter an order of dismissal? This case is dismissed as moot.
Well, I
I
don't
wonder
think
if it does
would-
contemplate more labor.
Well, the only labor that wouldn't necessarily be contemplated would be what was the ancillary issues of attorney's fees. I don't think that the court could enter a voluntary dismissal because Dragonfly had agreed to our entitlement to attorney's fees. And so the court would still need to take action on that.
Well, if the issues are moot, there's no legal action that the trial court can render on the primary complaint. That would leave ancillary matters perhaps still available. So normally, if you file a motion, to dismiss a cause of action as moot, there's nothing further to be done because the parties have agreed to possession. Wouldn't there be a subsequent order of dismissal from the trial court ending the proceedings?
I don't think so, Your Honor. I think
Okay.
this was everything that was designed to resolve of everything on the merits. There was never anything else intended. I think we can even see that from the conduct and how everything in the trial court has since transpired. Everyone agreed that this was how the merits were resolved. Everyone agreed that there was a prevailing party. This was intended to resolve the merits in its entirety. And so then going to the merits of the argument, which I don't think this court should jurisdictionally reach for the reasons I've noted, but if it is inclined to address the merits, the court should affirm, because the trial court did correctly conclude in this case that COVID-19 was not a force majeure event. My opponent's briefing, and I think today he's focused on trying to say we should interpret this force majeure provision to be consistent with the general purpose of a force majeure clause. The parties understood what a force majeure provision was designed to do. They included it in this lease. They, however, just decided to impart a narrow force majeure provision into this actual lease. And if there's the beauty of the freedom of contracting that we have in this state, it's that the parties are free to set the limitations on their force majeure provision however they see fit. And when they define what constitutes a force majeure, it's those contours that they've bargained for that dictate the application, effect, and scope of what constitutes a force majeure event. And here, the clause says we have 6 specific reasons, which we've already talked about this morning. And then it says, or other reason of a similar nature. And I know my opponent wants to say, well, we can't just stop at similar nature. We need to go on to say, and read the rest of the provision that says that is not the fault of the other party or the non-performing party. But read in its entirety and according to its plain language, I think we have to say that we have to have 2 things, right? One, the other reason still has to be similar in nature to the 6 specifically listed reasons. And then second, that similar in nature reason has to not be the fault of the non-performing party. Here, Dragonfly in the trial court focused on, well, you can't get past it, COVID not being similar in nature to our 6 specifically listed reasons. And that's because when we think of something, the nature of something, we're talking about a basic characteristic of that event or condition, something that when we speak of basic, we're talking about foundational or a starting point for that event. And like the trial court noted, COVID-19 is a virus. And the best case I think I could direct the court to that talks about what the nature of COVID-19 is the In re Art Van Furniture case. And In re Art Van Furniture says, look, COVID-19 is a virus, and a virus is a natural condition. Natural conditions are definitionally not something that are man-made. They don't require conscious human conduct to come into existence. And that is differentiated from the things that we have specifically listed in our provision here. Acts of war, riot, insurrection, strikes, lockouts. That's the dividing line here, and why the trial court did correctly interpret this force majeure provision to conclude that COVID-19 was not a force majeure event. And so for that reason, if the court is inclined to address the merits, we would ask that it affirm. But as I stated, we think there is no jurisdiction under Ginelli, Grassland, and Hutchins. And so to paraphrase Justice Roberts when he was on the DC Circuit, I would think the cardinal rule of judicial restraint would be not to decide more if it's unnecessary to do so. I would focus first on the jurisdictional component and either dismiss under Ginelli and Grasslands or strike and affirm under Hutchins. Thank you.
Thank you, counsel. Okay. Mr. Morgan, you have your remaining 5 minutes, counsel.
Thank you, Your Honor. May it please the court. Just want to briefly discuss the jurisdictional issue, if I may. Procedurally speaking, the underlying case did not proceed as you would normally expect. For example, what I mean by that is that plaintiff Midway filed their motion for summary judgment based on their request for possession of the property. Likewise, defendant's motion for summary judgment and amended motion for summary judgment address just Midway's claim. Procedurally, it should have also addressed the counterclaim for declaratory action. It did not do that. In essence, however, the summary judgment order does address that issue and determines that the force majeure clause doesn't apply. Unfortunately, it is not a final order as well. So what happens is the agreed order in December of 2020 does address the possession issue to prevent the evidentiary hearing. At that point, Midway was the prevailing party. They had prevailed at summary judgment, even though procedurally it wasn't necessarily on the counterclaim, on the deck action. They had prevailed. They were the prevailing party. There was nothing to be done other than to get a final judgment on everything, the counterclaim and the complaint. That was not done in the December order. I don't know why it was not included.
Is it your position for purposes of this appeal that the agreed or final judgment on fees adjudicates the counterclaim?
It does, Your Honor, and the reason why it does is there is finality language in that order. It makes the Midway the prevailing party, although that had been done, but then goes on to say, gives the finality language of for which let execution issue, meaning there's nothing more to be done in this case. I wish it had addressed specifically the declaratory action. It did not do it specifically, but it does finalize it generally by giving that finality language. And because of that, the notice of appeal was filed timely, and the court has jurisdiction and can make its decision based on the substantive arguments that both Mr. Brockmeyer and I have briefed. And I'll leave the court with that, unless you have questions.
There does not appear to be further questions. On
Yes, sir.
behalf of the panel, we thank you for your presentations today and wish you the best and good health, and hopefully next time, well, there won't be a next time. I guess you guys will be appearing before the 6th in the future. So we thank you for your presentation and stay well.
Thank you, Your Honor.